because that's within our, what you call, coverage on the business sector side. Other than that, whether it be CONCON, Constitutional Assembly, I leave it to the wisdom to our legislator. Primarily, of course, you have to consider the financial capability, the timing, and that it will not disrupt in any way the normal operations of businesses and also for the legislator. We have seen in the past that the government in the past few administrations have been very proactive in allowing our country to be more attractive to foreign direct investments. In the past, we have a few laws that has been able to help us: the Public Service Act, the Retail Trade Liberalization, the Foreign Investment Act, the Konektadong Pilipino, and some of the other laws that really open up our country for foreign investments. But there is this sticking issue of why the foreign investors are not coming, although we have provided, ample liberalization on investment. Now companies can invest in our power, in telecom. Okay? Of course, there's some restriction as far as agriculture. We still stand that we have to protect our sovereign rights as far as exploitation of natural resources and land ownership. Okay? Now, let me go back to why our investment has not been as progressive as other ASEAN countries. We know very well now most of the investments are going to the countries like Vietnam. Okay? And I did check on the difference between their constitution and our constitution. We are a multi-party system. We have 3 branches of government. While Vietnam is a single party, very similar to China. So somehow that gives them a leverage of doing things faster. But not taking away from, our system of government, we have also has a good track record as far as our PESA, Export Processing Zone. We have the opportunity of meeting a lot of foreign delegations that come to the Philippines, expressing their desire to invest in the Philippines. And just to share with you, most of them would like to be in PESA. The reason why is because of the ease of doing business. There's no contradiction as far as the interpretation of the laws. And first and foremost, really, for us to attract more foreign investments, is the ease of doing business. And definitely, on our part, I have the privilege of, in both administrations, the administration of President Duterte and President BBM, I've traveled with both presidents in their trips to foreign countries to attract foreign investments. And we always put our best foot forward. But we do have some real issues as far as the availability and affordability of our power. Yeah, we're quite lacking in that. And also our logistic cost is one of the highest. I cannot imagine how many kilometers of roads would have been built if not for what we're experiencing on the PWH scandal. Yeah. So all of those comes into play as far as being able to attract foreign investment. Yeah. So with that, Your Honor, we are here to hear whatever proposal that would really bring our country's economic development, that would provide inclusivity, okay, and fairness equitably. We are very concerned that our economy is hollowing out because we don't have too much manufacturing. Okay? We are basically a consumer economy. We live off the remittances of our hardworking OFW, which is about $40 billion a year. Okay. In one of the, may I say, sunrise industry, of course, is the BPO. Okay. But that again, we are quite concerned with the disruptive technology of artificial intelligence. It's being talked about that if we do not catch up early, we may lose a lot of jobs in this sector. And what I'd like to end is that we really have to focus on our agri-aqua industry. For a country that is an agricultural base, we import a lot of food-related items. Just to share with you, our trade deficit with our ASEAN countries is about more than $40 billion. Ibig sabihin, yung dollar natin, we are buying our goods mostly from outside. So that by itself reduce our job opportunities. So that's one area that we're quite concerned. Now, on the side of, we have made a discussion on the education side. Okay? We're now, the education sector is still restricted to Filipinos. And maybe that can be looked into as far as higher education that are focused on medical, sciences, and mathematics. Okay? If we can learn from others, maybe on those certain educational discipline, we can be more liberal about it. So with that, I'm sharing my thoughts, and I hope that those things can be looked into in the discussion of changing our constitution. It's 38 years since the last major change, so we are all in agreement that it's about time that we tweak it a bit. Maraming salamat po. Thank you.
Thank you, Chairman Barcelon. Let me thank the PCCI for inviting me. The previous Congress, we approved in the House economic provisions, amending 6 economic provisions, but unfortunately, the Senate did not act on that. So we're back here to again find out what is the best mode. As you have said, you're very much interested in the economic provisions, and you give it to Congress to decide whether it should be by CONCON or CONAS. Thank you very much for your thoughts. Thank you, Chairman. Before we proceed, let me just acknowledge the Dean of the San Beda Graduate School of Law, the Reverend Father Ranilio C. Aquino. Thank you for coming, Father. So now we will proceed, and we would like to hear from Attorney Catarina Gabriel Cosalan of the Philippine Stock Exchange. The floor is yours, ma'am.
Good morning, Mr. Chair. Good morning, Your Honors. Thank you for inviting the Philippine Stock Exchange to this public consultation. The PSE fully supports the amendment of certain economic provisions of the 1987 Philippine Constitution, specifically the easing of restrictions on foreign participation in the following areas of investment, which are currently reserved for Philippine citizens and corporations. First is the exploration, development, and utilization of natural resources. Second is the operation of public utilities. Third is the operation and ownership of educational institutions. And fourth is the ownership and management of mass media institutions. The grant of authority to Congress to eliminate or at least lessen by law these barriers will pave the way in attracting more foreign direct investments into the Philippines. Your Honors, at this juncture, the PSE would like to emphasize that openness to foreign ownership is a key criterion that investors look at when rating the quality of a market. So index providers, or let's say investment research firms such as MSCI or Morgan Stanley Capital International and FTSE, Financial Times Stock Exchange. These index providers create benchmarks or standards for stock market performance. They provide investment decision support tools for investors. So these index providers, Your Honors, they have classification systems which categorize markets, in this case, the Philippine markets. And under these classification systems, there is market accessibility. And on the criteria under market accessibility, I will just mention three which is relevant to our discussion today, Your Honors. Openness to foreign ownership, ease of capital inflows and outflows, and the third is incidence of foreign ownership restrictions. So these classification systems, Your Honors, are used by these index providers to construct indices. So, Your Honors, what are indices? These are statistical measures that track the performance of a certain market. In this case, again, the Philippine market. Also, these classification systems are used by these index providers to compare the different markets from one another. Your Honors, as to the mode of amending the 1987 Philippine Constitution, the Exchange fully supports the calling of a constitutional convention. With this, the PSE would like to recommend that House Bill number 3068 and House Bill number 5870 include a provision establishing a committee composed of representatives from various sectors which will guide the delegates accordingly on policy considerations. We suggest that these representatives should be experienced experts from the following sectors, among others: economics, finance, law, health, tourism, labor and migrant workers, agriculture and fisheries, transportation, science and technology. So for the kind consideration of this honorable committee, Your Honors, the Exchange will submit its position paper by next week. Thank you.
Thank you, and we would certainly study your proposals on, you are in favor of opening our markets, as the three indices would be very important
Yes,
for
Your Honor.
our economy and then the Philippine Stock Exchange. Thank you very much, Daniela Attorney Posalan.
Thank you, Your Honor.
So we now proceed with Mr. President of the Canadian Chamber of Commerce in the Philippines. We have Mr. Christopher Ilagan. Please proceed.
Good morning, Honorable Chair. Good morning, Honorable Committee members. I have a prepared statement, and then I'll answer a couple of the other questions you had posed separately. So, the Joint Foreign Chamber of Commerce of the Philippines strongly supports the amendment and/or revision of the 1987 Philippine Constitution, specifically the removal of restrictive economic provisions. The Joint Foreign Chamber has consistently advocated for the reform or removal of foreign equity restrictions, as these restrictions are inflexible and outdated. The embedding of rigid economic provisions in the Constitution has deprived the government of the necessary flexibility to freely adjust to future changes in technology, meet requirements under international treaties, and capitalize on new economic opportunities. Moreover, the restrictive provisions reflect a nationalistic and protectionist spirit from the 1935 and 1973 constitutions, an approach that no longer aligns with today's globalized economic environment. With the Philippine economy integrated into the global economy and engaged in numerous free trade agreements, these old provisions no longer serve the country's best interests. These restrictions undermine the country's competitiveness. They contribute to lower investments, fewer jobs, poorer infrastructure, and less inclusive development. Major international organizations, including the World Bank and the OECD, consistently cite the Philippines as one of the most restrictive economies for foreign investment worldwide. The most direct and effective way to address this challenge is to remove these constitutional barriers entirely. Now, on the question on whether it's a constitutional convention or a constituent assembly, we prefer not to comment. We rely on the wisdom of our legislators in Congress to decide that. But in terms of the specific provisions, our intent is to submit a full-fledged position paper. But to the point of Honorable Co. Pilar, right? The same sections that were raised in your speech earlier, 12, 14, and 16, are precisely the same ones that we would like to see changes to. Historically, we have taken the position of inserting where appropriate unless otherwise provided by law. But if there is an opportunity actually to take a look and see if we can outright remove those sections, this may be the opportunity to do that, right? And so, we would invite the Congress to look into that. We will submit our position paper, and where we think it might be appropriate to actually just strike it out entirely. But we look forward to continuing engaging, and thank you so much for inviting us.
Thank you, Mr. Ilagan. So we would certainly value your statements and the position paper you're going to submit. That is from the Joint Foreign Chambers of Commerce of the Philippines. Now we go to Ms. Mariel Angela Soriano, also the Advocacy Engagement Specialist of Arrancada Philippines Project and the American Chamber of Commerce of the Philippines. Yes, Ms. Soriano, you are recognized.
Good morning, Mr. Chair and the honorable members of this committee. On behalf of the JFC, which includes the American, Australian, New Zealand, the Canadian, European, Japanese, Korean Chambers of Commerce, and the PAMURI, or the Philippine Association of Multinational Companies Regional Headquarters, we express our support for proposals to ease or remove the economic restrictions embedded in the 1987 Constitution. We appreciate, of course, the opportunity to comment on the measures included for today's discussion. The JFC has long supported to easing the restrictions of foreign direct investments wherever this is possible. I think you would remember since the time of our former director, John Forbes, he has been actively participating in hearings on this matter. The removal of constitutional barriers can facilitate increased LDI in sectors where investment remains constrained, complementing the progress Congress has already achieved through the reforms of the passage of the Public Service Act, the Foreign Investments Act, and the Retail Trade Liberalization Act. We fully recognize the government's mandate to safeguard national interests. In many economies, we have seen that such safeguards are implemented through legislation or executive regulations rather than through permanent constitutional provisions. And thus, this approach would also allow the government to adjust quickly to technological changes, international commitments, and emerging global opportunities. Ultimately, the global economy increasingly depends on the free movement of capital and on a level playing field between the domestic and foreign investors. Providing clarity, flexibility, and openness in our investment environment is vital to sustaining competitiveness. We thank the committee for its attention and stand ready to work with you in promoting reforms that will enhance the country's economic growth and long-term development. Thank you, Mr. Chair.
Thank you very much, Ms. Soriano, for your comments. And we would also request the position paper because we wish to put a matrix of the statements and the positions of all our resource persons. You are the morning session. We have also in the afternoon session. And so now we proceed to hearing the President of the Foundation of Economic Freedom, Toti Chicamco. The floor is yours.
Maraming salamat po, Your Excellency, Congressman Rodriguez. First of all, I'm happy to note that Congress is moving toward addressing the structural problems of the Philippines. It's not our problems such as it's a matter of graft and corruption or putting moral people in government. It is a structural problem which arises from the defects of a constitution that was made more than 30 years ago. So, with respect to the mode of changing the constitution, I support a constitutional convention in 2028 in the same time that there will be elections. The reason for this, of course, is a constituent assembly is quite controversial because of the suspicion of some people that Congress will only enact legislation or a constitution that's favorable for them. Besides, a constitutional convention will gather the widest possible participation of our people in changing the constitution. Unlike the 1987 constitution, in which only a few appointees crafted the constitution. As to what changes I would like to see in the constitution, there are a number. One is, of course, to remove all Filipino first and Filipino-only provisions in the Constitution, because these provisions have only resulted in the development of monopolies and oligopolies in the country. We need to remove all those Filipino first and Filipino-only provisions in the Constitution. The second thing is, I think, we need to develop a strong political party system in the country with state funding for political parties. So there's no more need for individual politicians to raise their own funds to be able to campaign and get elected. If we look at the history of other countries that have successfully developed, strong political parties have been behind their development. We can mention the Kuomintang in Taiwan, the LDP in Japan, the Communist Party in China, the PAP in Singapore, UMNO in Malaysia. You have also the Communist Party now in Vietnam. So strong political parties are behind development. So we need strong political parties. If we do not have strong political parties, the default will be, of course, political dynasties, because that's the only system of collective action. So we need to put in place a strong political party system with state funding for political parties. The other change that we would like to see is, of course, we need to shorten our constitution. It is one of the longest in the world. Therefore, it's straight brackets the country whenever there are technological or other changes. We need to shorten the constitution and let legislation take care of whatever restrictions or other developments that must be put in place to protect the Philippine economy. Finally, I think we need to put education as a center for social justice, as equalizing reform. So rather than asset distribution or taking away the land from another to give it to somebody, we need to put in place education as a center of equalizing reform for all our citizens, rather than asset distribution. So those are the things that we would like to see as changes in the Constitution. Maraming salamat po.
Thank you, President Toti Chicamco of the Federation of
Foundation.
Foundation of Economic Freedom. Thank you so much for your comments. And before we proceed, let me just acknowledge we have the Deputy Minority Leader of the ML Party List, the Honorable former Secretary of Justice, Laila M. De Lima. Welcome to the hearing. And we also would like to welcome the Deputy Minority Leader of ACT Teachers Party List, Honorable Antonio Tino. Welcome. And so we proceed now with hearing from the UP College of Law, and we would like to hear our two representatives, Associate Dean, Attorney Paulo Tamase and Attorney Oliver Reyes. Please proceed.
Mr. Chair, committee members, good morning. Law Center is very thankful for your invitation for us to assist the committee in the consideration of these proposals. we will submit a full position paper including the pros and cons, in particular of constitutional conventions and constituent assemblies. But if I may already premise what we will submit, the premise of our analysis, Mr. Chair, is that the people are central to our constitutional government. It means that their buy-in and trust in any process that will change the fundamental charter is necessary. If we look at our longer constitutional history, there have been many attempts, almost attempts in every Congress since 1987, to have some amendment or revision to the charter. And uniformly, that those efforts have failed, whether in Congress or outside, through people's initiatives, because of a few things that our scholars in the Law Center have written about before. The first is the lack of certainty in the process. If we look at the textual ambiguities in Article 17, every time that we have a hearing in the House or in the Senate, we talk about whether the Senate or the House should vote separately or jointly, or should meet separately or jointly. There are, of course, views from academics as to the proper mode, but the lack of certainty and ambiguity increases the cost of an amendment, which may disincentivize people from engaging with the proposed amendment seriously. The second, and perhaps the more important block to successful change in the Constitution, would be public trust. And I think, as mentioned by the Foundation for Economic Freedom, changes in the Constitution have been dealt with suspicion in the past because they were perceived, notwithstanding fair debate and comment on whether we should have economic changes or changes to the economic provisions, they were often perceived as simply Trojan horses for larger changes on the political structure and term limits. This means, Mr. Chair, members of the committee, that the important conversations of whether the Constitution is still current are left out. And mature democracies rely on an intelligent, ongoing public discussion of what is truly fundamental to their society. Hence, we would suggest that any process to change the charter must be done in a transparent manner and not cut corners. In the past, I understand that there may have been ideas or suggestions, for example, for the House and the Senate to vote jointly because it would be the faster process. But unlike past occasions, we are perhaps just from a scholarly perspective, from an academic perspective, in the highest constitutional moment that we've had since 1987. In the sense that the people, because of the flood control issue, have come to the realization that if the failure is systemic, then maybe the system needs changing. So the House may wish to take advantage of that earnest desire of the people to seriously talk about their constitution in a mature democracy by going through the longer, more difficult process. That means that if the House were to propose amendments to the charter directly, or if it were to call for a constitutional convention, then the least common denominator would be for the houses to vote separately but meet jointly. This would be the more arduous process, but it would satisfy the least common denominator of what it would mean to actually engage in this very important conversation. Now, as to the actual amendments, in addition to what Congress has already proposed to the bills, one important amendment may actually be clarifying Article 17. And that involves, cleaning up, Mr. Chair, members of the committee, the ambiguity between whether the process really requires the houses to meet and vote jointly or separately. It seems like a very minor change to the Constitution, but the idea is to have a Constitution that balances both the required rigidity of a fundamental document that is not subject to policy changes for every few years, and at the same time being a current document that addresses really the fundamental needs of the people. So that openness, that transparent process is necessary, whichever mode may be chosen by the committee and by the houses eventually. We will submit a full position paper on this, but we would be happy to answer any questions that you may have in today's hearing and in the coming meetings. Thank you, Mr. Chair and members.
Thank you, Associate Dean Paolo Tamase, for your comments and for the College of Law and the Law Center. So we would like to hear now Attorney Oliver Reyes for your comments.
Good morning, Your Honors, Mr. Chair. I do wish to manifest that I entirely agree with Associate Dean Tamase and the position of the Law Center, and I would like to devote much of my time to actually just reinforcing several of those points. So, firstly, I do think that it is nearly anomalous that we have not really changed our constitution. I mean, especially when it comes to the experiences of other countries, constitutional amendments do happen as part of the normal course of a nation's life. But of course, in the Philippines, any discussion of constitutional amendments trigger this paralyzing existential crisis that ultimately deters any amendments. And I don't think that that was really the design of the Constitution, which after all does allow for amendments, and in fact tried to open up the amendment process by introducing the concept of people's initiative. But I do agree that a lot of the issues, in fact a lot of the perhaps even deterrence to even pursuing any kind of amendment, is the lack of clarity when it comes to Section 1, Article 17. Now, any serious attempts to amend the Constitution would have to hurdle, and in fact would require both the House and the Senate to come up with, at the very least, a provisional interpretation of what this provision means in order to actually enact the amendment. And the problem is, if more significant amendments, more substantive amendments were to be pursued on the guess that this is how the Supreme Court will affirm the interpretation of Section 1, Article 17, that is an investment that may be ultimately lost because it will all await the Supreme Court's word. But if the initial amendment to be pursued actually centered on Section 1, Article 17, and then the Supreme Court rules on the issue of voting jointly and separately, or affirms or rejects how both houses of Congress had proceeded, at least now there would be this clear guidance from the Supreme Court as to how to be able to successfully pursue other amendments. So perhaps that is really something worth considering. And also, moreover, on the point of needing to build public buy-in towards the Constitution, an initial discussion on amending the Constitution to clarify Sections 1, Article 17, can already test the waters, so to speak, as to the public appetite in amending the Constitution now. And I do think that with all of the flood control scandals, with the impact that has had on public trust in our institutions, this is as opportune a time as to perhaps discuss even these existential questions. And I do think on the point of whether or not to pursue amendments or to call for a convention, I think that to call for a convention and to essentially undertake a revision of the Constitution, an entire holistic analysis of the structural changes, as part of the need for transparency and public confidence, I think it should be understood that this would be a measure that would require actually, and for at least a few years, a redirection of the public focus, of the focus of our institutions, of our public discussions on how do we proceed forward as a nation. Because after all, the Constitution is the foundational document. And I think that a constitutional convention and a revision, I think it should be understood that if we do decide to embark on this process, re-examine the whole Constitution, it would require this redirection of the public focus. And I think that that should be part of the buy-in that would be required. But at the same time, as I said, it should not be that difficult systemically to amend the Constitution. And and I do think that a lot of the proposals, which I'll reserve comment on, but a lot of them would only entail amendments. And the clarification of Section 1, Article 17 would go a long way to, well, having those discussions. Thank you, Mr. Chair.
Thank you very much, Panyero, Attorney Reyes. And we would like to, before proceeding, welcome Congressman De Maguila for coming, Arman, for coming to this hearing. Thank you very much for coming. And so we are about to have the last speaker on the private sector, because after Dean Aquino will hear our officials of government. So you would like to hear now the Reverend Father Ranhilio Aquino, San Beda Graduate School of Law. Please proceed, Reverend Father.
Good morning, Your Honors. I also respectfully request for the opportunity to submit a position paper after this. I favor an amendment of the Constitution if we are minded to go no further than an amendment. Aside from the grounds advanced in the privileged speeches that introduce the measures, the issues our nation has had to grapple with lately demonstrate quite clearly to me, and perhaps to others as well, that systemic change is necessary. Frequently, objections to amendments of the Constitution are tied to some kind of a sentimental attachment to the 1987 Constitution. There is no doubt that it is a well-written Constitution, but that is not to say that it cannot be improved. I favor the position expressed by the UP Law Center that amendments to the Constitution or even a revision of the Constitution calls for the involvement of as wide a spectrum of Filipino society as possible. This means that consultation on fundamental levels of society, LGUs, barangays, youth, should accompany the groundwork for constitutional amendment or revision of the Constitution. I also seriously advance the proposition that it would be good to get the support of the church. It's not because I'm a priest, but the fact is that the church has considerable influence in Philippine society. And so to get the church on board and to make use, for example, of consultation through its basic ecclesial communities would be very good. It is common to dismiss the need for system change with the easy contention that it is people that need to change, without in any way being dismissive of the truism that we need civic spiritedness among those who hold public office, as well as among those who choose those who hold public office. It is, however, a position I strongly maintain as a professor of philosophy, as well as of comparative constitutions, advocating, well, that decision-making processes of persons are conditioned by systems. So it's not correct to say, change the people and the system will be okay. No, because in many ways, systems do condition the way people act. And so we do need to take a look at the system. systems channel the decision-making processes of persons and condition public life. I am by no means advocating a clean sweep of the 1987 Constitution that is in several respects exemplary. Nobody, I think, would support the proposition that every single section must be rewritten and every salutary provision of the 1987 Constitution, drafted to my mind by people of integrity, probity, competence, and noble intention, should be stricken off and set aside. However, Your Honors, the theory of constitutionalism is precisely that society can be reorganized and its body politic reconfigured by rewriting the Constitution. It is for this reason that I favor not only an amendment of the fundamental law, but as the Vice Dean of UP Law said, a revision as well. And the principal revision I strongly advocate is a system of government that puts a premium on the accountability of government. And given the different political configurations of the branches and offices of state that we are taught both by history of the constitutions and of states, the parliamentary system is one that holds government constantly to account to the representatives of the people. The fact that the Prime Minister and his ministers sit in Parliament and must respond to questions and challenges that arise not only from across the floor, but from backbenchers as well, convinces me that the parliamentary system is one that allows for a constant check on government. I know that the objection will be heard that we have never tried the parliamentary system in the country, at least not the parliament of the Westminster type. For while it is true that the 1973 Constitution intended us to have some kind of a parliamentary government, the vast powers granted the President under the contentious Amendment Number 6 made an experience of genuine Westminster-type parliamentary government virtually impossible. Together with the shift to a parliamentary system and as its presupposition, I advocate a constitutional framework for the establishment, maintenance, and support of a viable party system and the adoption of proportional representation. I was part of the 2016 committee tasked to study the 1987 Constitution. And while I was averse to proportional representation, in large measure because I did not see the point to it, it eventually occurred to me that you cannot promote a party system in the Philippines, a nation that tends towards populism, without the system of proportional representation that compels voters to look to parties and what they advocate rather than persons and the families they come from. If, however, this committee and other committees are minded merely to confine itself to amendments, I submit that the following measures need to be addressed. One, a self-executing provision that bans dynasties up to the second degree of consanguinity and affinity, whether successive or simultaneous. Second, the abolition of the party list system that has been mangled beyond recognition and prescribing for part of the membership of the House of Representatives by proportional representation. Third, amending Section 22, Article 6 of the Constitution so that cabinet secretaries and officials of the executive branch are subject not only to invitation, but to compelled and mandatory attendance without Congress or its chambers or committees having to justify its summons by claiming to be acting in aid of legislation. The oversight to which the legislature, I submit, is entitled is sufficient constitutional justification for this grant of power. Fourth, our experience with congressional investigations that do not result in prosecution has been a source of national frustration. I propose that when Congress conducts a hearing, whether in aid of legislation or pursuant to its oversight functions, and the committee report, as confirmed by the plenum, finds probable cause against perfidious public servants, the report itself becomes the basis for prosecution, making it ministerial on the part of the National Prosecution Service or the Office of the Ombudsman to file the corresponding information before the court of competent jurisdiction. Your Honors, I favor a constitutional convention because constitutional amendments or revisions introduced by the chambers of Congress exercising constituent powers will always invite the suspicion that the actuations are self-serving. I do propose, however, that a constitutional convention be constituted, one half of the members of which are elected and the other half appointed from experts in constitutional theory, political science, economics, commerce, social theory, and juridical science. I shall submit my position paper after this, Your Honor. Thank you very much.
Thank you so much, Reverend Father Ranilio Aquino of the San Beda Graduate School of Law. Before we proceed, let me acknowledge the presence of the Honorable Rene Co of the Kabataan Party List. Welcome. And I see also Len Oreta, Congressman of Malabon. Welcome to the hearing. Now we are through with the private sector. We will hear now representatives of government. So thank you for coming here and to be able to give your position. And now, first we'd like to call on Assistant Director Judith Gondra of DepDev. The floor is yours. Thank you.
Thank you very much, Mr. Chair. Thank you for inviting DepDev to the hearing. So, we will be submitting our official position paper next week. But for now, we can say that DepDev supports the intention to amend economic provisions of the 1987 Constitution for the following
Please have your microphone really in front.
Okay, for the following
We have a
reasons.
problem with the sound.
Sorry. Okay, Mr. Chair. Okay. On the economic provisions, specifically those that restrict ownership, management, and control of certain enterprises and activities have contributed to low foreign investment inflows and scarcity of major global enterprises in the country. These economic restrictions, in turn, have led to limited access to economic and social opportunities and the proliferation of highly concentrated markets, ultimately reducing consumer welfare. No, and amending economic provisions enables the country to adapt to current and future socioeconomic conditions. And this support is driven by a collective desire to economic and social transformation that will be instrumental in uplifting the lives of all Filipinos. And amending the economic provisions is expected to result in positive gains and provide the Philippines with additional tools for prosperous, inclusive, and resilient economy in the form of more foreign direct investments, international education, globally competitive mass media, international advertising, and modern utilities. Now, the proposed amendments will also allow flexibility in the Constitution to respond to different political, economic, social, technological, legal, and environmental shocks accordingly and in timely manner. No? However, DepDev notes that lifting the foreign investment participation alone will not solve the country's position in attracting strategic foreign equity, but it is just one of the factors that need to be addressed, no, Mr. Chair. So, in terms of the mode of amendments, it will be form part of the our position paper, which we will be submitting next week, no, as we are currently updating our comparative matrix as to the modes, if it is con or con-as. No, we will be also submitting our assessment of in terms of costs no, of both mode of amendments. So that would be all, Mr. Chair.
From the DepDev, and also from DepDev, we'd like to hear Ms. Janice Putanes, the Supervising Economic Development Specialist.
Good morning, Mr. Chair and honorable member of this committee. Just to add to my principal, AD Judith Condra, I would like to answer the question, what specific amendments do you want to propose? Like she mentioned a while ago, we want the committee to consider the following sections: the one on public utilities, on education, on mass media, and on advertising. And then just to add to her manifestation, we believe that lifting the foreign investment participation alone will not solve the country's weak position in attracting strategic foreign equity, as it is one of the critical constraints that we need to address. These number of we call these factors, such as predictable investment environment, the market size, and the level and quality of infrastructure, peace and security, our tax regime, and political institutions. That's it, Mr. Chair. Thank you.
Thank you very much, Ms. Putanes. Now, for our last resource person, we'd like to invite Yusek Domini Velasquez, Chief Economist, Department of Finance. The floor is yours, ma'am.
Good morning, Mr. Chair. Thank you for inviting us here. I think most of the things have been mentioned by Mr. Barcelon and DepDev for the DOF. We also welcome this review, especially for the economic provisions. We can recognize that in the past 10, 15 years, the country has been very open to foreign direct investments as with the help of Congress, with the liberalization reforms that we've put in place. This administration, the stance remains the same, as we've also pushed for not just the liberalization efforts, but leveraging on this with incentive packages such as Create More and the Foreign Investor Long-Term Lease Act and the like. So right now we're at the stage where we want to encourage foreign investments through these liberalization reforms we've done in the past. Unfortunately, we recognize also that this is very uncertain times. We have not seen much of the fruits of these liberalization and incentive reforms just because of the uncertainty in the global environment. For us, similar to our position before, we welcome much more needed liberalization of economic provisions, possibly with public utilities, advertising, maybe higher education. We also want to note that the 2023 OECD data with regard to restrictiveness of regulatory FDI Regulatory Restrictiveness Index puts the Philippines second to the most restrictive in ASEAN. So that's after Laos. So Philippines, Malaysia, Indonesia, and of course at the end of the spectrum, Singapore. Additionally, we wanted to note that foreign direct investments to spur for FDI, it's not just limited to the regulatory reform or liberalizing it. There are other factors such as ease of doing business, good governance that require a review for the country's overall attractiveness. So in terms of the mode of amending the Constitution, the DOF has no specific recommendation. We defer to the collective wisdom of Congress on this. Thank you, Mr. Chair.
Thank you very much, Yusek Velasquez. So now we will ask our members if they have questions to propound to our distinguished resource persons. We always start with the minority. And in the minority, the first come, first serve. The same also with the majority, first come, first served. So we'd like to ask, the first one who arrived from the minority is the Honorable Laila De Lima for your questions, rhetorical questions. Thank you.
Thank you, Mr. Chair. Good morning. Good morning to our distinguished resource persons. I just have a few preliminary questions at this point. This is the first time that I have attended the committee hearing of this committee. I don't think there is hardly any debate that the Constitution needs some adjustments already, some changes, some modifications. Now, I just want certain clarifications here. Are we pushing for just amendments or revisions? Will the proposed constitutional convention be dealing with amendments on specific issues or priority areas for changes, or are we talking here about revisions? Because we all know that amendments and revisions to the Constitution are two different concepts. Can we ask any of the distinguished sponsors or authors of the pending bills to please clarify? Because the reason why I'm asking this, Mr. Chair, is in House Resolution number 460, it says, a resolution calling for a constitutional convention to propose amendments to the 1987 Constitution of the Republic of the Philippines. This was filed November 12. But the day earlier, actually, the bill itself, which is House Bill number 5870, filed or authored by the same authors of the resolution, resolution number 460 says, well, the title is an act calling for a constitutional convention to propose amendments, revisions, corrections, and changes to the 1987 Constitution, setting the election date of delegates, prescribing the composition, powers, and functions of the convention, providing for its appropriations and for other purposes. So this is broader, not only amendments, but also revisions, corrections, and changes. So am I correct in perceiving that we are actually contemplating here or envisioning revision and not just amendments to specific items, the ambiguities? Because I do believe and I agree and I concur with the idea that we need to clarify ambiguities because there are ambiguities. Sa ano pa lang, dun pa lang sa impeachment, the forthwith terminology, the use of the term forthwith, and with the Supreme Court decision, it looks like if it's not reconsidered, then it's next to impossible if any future complaint for impeachment would prosper. And then this voting about whether it's jointly or separately on certain items. So can we be clarified, please? Because to me, this is very crucial, whether we are talking here about just amendments to the more important and more urgent provisions, or we're talking here about revisions.
Thank you,
Which would be
Congresswoman De Lima. Before Deputy Speaker Pudo can answer that question, may I recognize Deputy Majority Leader Arnan Pangaligan. Thank you, sir. Deputy Speaker Puno is now recognized.
Thank you, Mr. Chairman. Your Honor, we purposely avoided specific amendments in the resolution that we submitted. Our resolution intends to define the method that will be used in order to either revise, amend, or otherwise deal with the Constitution. We feel that there are just so many specific amendments that can be brought forward by many experts. And we do not presume to be experts in all fields. We did mention some inconsistencies and ambiguities that we felt should be immediately addressed
But the body of the resolution merely provides for the method of how the Constitution will be reviewed. So it was our hope that in the proceedings in this committee, that if such ideas will come in as to whether or not there should be clarifications or actual revisions, that this should be discussed in committee. We did not presume to be knowledgeable about what would be the best course of action for the committee at that time. So we believe that this format of our resolution will allow for more discussions to give substance to the method that we're going to use for the Constitution. It merely stems from the fact that there have been people's initiatives that have been ruled down and stricken down by the Constitution a number of times over the many years. It comes at a time when both houses of Congress are under criticism by many quarters for various actions done by both houses. So we feel that, for example, a constituent assembly is probably not the best suggestion to make at this time if we are going to seek the full confidence and faith of our people. And we don't believe that a people's initiative is any longer feasible, especially under the situation where the Supreme Court has already ruled many times about the various efforts at a people's initiative, which leaves us only with a constitutional convention to deal with these issues. So, in summary, our resolution merely provides the methodology and venue for the consideration of these issues, Mr. Chairman, Madam.
With that explanation of our distinguished colleague, our distinguished sponsor, I take it therefore that you are confronted with two situations here. So one is that this proceedings, these discussions at the committee level does not exactly foreclose the idea of already identifying certain priority areas for possible amendments. Correct? Already identifying in the bill.
Yes, if I may, Mr. Chairman,
Does not foreclose, actually. Or it will also be, one scenario also is that the Constitutional Convention as envisioned in the bill is, we would be given full discretion to determine the scope of amendments that can cover even the form of government, and then, for example, also even the proposed abolition of the party list system, as mentioned by the Reverend Father Aquino. Good morning, po, Father. Good to see you here. So it would be given the Constitutional Convention as envisioned would be given the full discretion to determine the scope of amendments, and therefore it would not just be really amendments, but it would be revisions. So those are the two possible scenarios. We can be more circumspect and we've been more careful by already identifying what the specific priority areas or areas that will be covered by the amendments of the Constitutional Convention to be tackled by the Convention, or full discretion that would open the doors to all types of changes in the basic charter. Is that correct?
Yes, thank you, Mr. Chairman. The resolution that we submitted was submitted in the context of other resolutions already submitted to the committee for specific amendments and their own methods of amending the Constitution for those purposes. So we were anticipating that there will be a period of discussion and all of these resolutions would try to be reconciled. And therefore, the specific amendments that were mentioned by everyone else would also be brought to a discussion. With respect to what the Constitutional Convention will actually do, as we know, there are two steps to this Constitutional Convention. First, we have to come up with a joint resolution from 2/3 vote of both houses or either house of Congress that a Constitutional Convention will be called, after which a more specific law is called upon, which is also going to only require a majority where the particulars of the convention will be discussed, including what Your Honor, Mr. Chairman, has mentioned about the specific items that will be covered in amendments. So that is why we presented our resolution in this way, because it opens up, of course, the discussions for the second legislation that needs to be undertaken, which is to provide for the specific conditions that will govern the Constitutional Convention after the convention has been decided to be called by both houses of Congress.
The salt of the moment, because I just want to clarify really the parameters of the proposed bill, and I reserve the next hearing my proposals. Thank you.
Thank you, Congresswoman De Lima. In the order of priority, next to propound question is Deputy Speaker Puno, to our resource speaker, if you have any question.
Well, yes, thank you. There was mention of the possibility of appointing members to the Constitutional Convention by Dean Reverend Father Aquino. I was just wondering what details would enter into this process of appointment. Of course, we ask this in the context of the necessity to reassure everyone that this process is for the benefit of the entire country and not for different segments of our political spectrum. What if there is any? May I ask if there is any more specific idea on how such an appointment process could be conducted?
Your Honor, actually, the Constitution does not provide anything about the composition of the Constitutional Convention, and therefore, impliedly, the Constitution leaves it to Congress that convenes the Constitutional Convention to determine the composition of the convention. The reason that I proposed one half elected and one half appointed was that I was a minor seminarian, a high school seminarian, at the time of the elections for the delegates to the 1973 convention. And I know for a fact that even if the elections of delegates was supposed to have been non-partisan, it was actually very partisan, with many politicians openly supporting candidates to the 1973 convention. So knowing that that is a distinct possibility, it will be good to have one half appointed because of their expertise. And that is why, Your Honor, I propose that the appointees come from the ranks of those teaching constitutional theory, political science, political theory, social theory, and economics. That way, there's a balance between those who are there because they are popular and those who are there because they have the know-how and they have the necessary academic credentials for it.
Thank you, Mr. Chairman. We look forward to the position paper that the Dean will be submitting
Yes, sir.
to this committee. We hope that there will be more details submitted to this by our honorable resource person and the others, because these are the matters that will be covered in the second legislation that the Congress will be required to undertake with respect to the specific characteristics of the Constitutional Convention. It would be very helpful to us. You know, I think we all agree that that what is going to be critical to any constitutional convention is the quality of the delegates that will be brought there, the objectivity, and of course the nation-mindedness of those that will be there. So that is indispensable to any constitutional convention we are going to hold in place. So we would really look forward to your position paper, Dean, and of course also the UP College of Law and the other educational institutions that are involved in this process and will be coming in the later hearings. Again, these are going to be specific provisions that may be contained in the legislation that actually defines what the Constitutional Convention will look like.
Attorney Paulo of UP College of Law.
Thank you, Mr. Chair. I think we share the observation that the constitutional amendment provisions do not actually provide for an election. However, and because ultimately, in light of the climate, any change in the Constitution should be expected to come to the Supreme Court at some point for its validity. The deliberations of the 1986 Constitutional Commission seem to suggest an election. So I understand that this was already contemplated in the last Congress during the debates on the proposed amendment where there would be appointed members of the convention. But in our research for that undertaking, we found that the framers were quite categorical in terms of it having to be an elected convention. But perhaps in acknowledgement also of the importance of a broad public consultation, there is nothing that stops Congress from creating within the law for the convention a consultative committee that will be made up of appointed officers that can be consulted by the convention at their discretion and their will. Thank you, Mr. Chair.
Mr. Chairman, if the College of Law could give specific suggestions on how this thing might be done, we would welcome it because, again, this will be part of what might be contained in a defining law for the Constitution.
We will be happy to provide that, Mr. Chair. Thank you.
Attorney Paolo, since things was mentioned dealing with the deliberations of the Constitutional Convention, the framers of the 1987 Constitution, can you enlighten us on the discussion on the mandatory provisions, whether there was discussion on voting jointly or voting separately?
So, if we look at the records of the 1986 Constitutional Commission, the discussion of whether there would be a joint voting or a separate voting isn't present because of the accident that when the Article 17 was being drafted, the commission contemplated a unicameral Congress. So the text of the Article 17 actually reflects a unicameral Congress. The decision to pursue bicameralism is one of the last decisions that the commission took. And when they did, and the style was changed for the rest of the Constitution, there was, by some accident, leaving out the proper amendment to Article 17 to make it reflect a bicameral Congress. So that is reflected in the scholarship of former Supreme Court Justice Vicente V. Mendoza a few years ago when this issue was also up. If we look at the 1935 practice, the 1935 text of the Constitution is definitely more categorical. The text, and I am paraphrasing a bit, says that Congress, by joint session assembled, may propose amendments to the Constitution or call for a convention voting separately. So those joint meeting and voting separately were explicit in the 1935 text. Unfortunately, because of the amendment of the drafting history, rather, of the 87 Constitution, it was not as clear when we got to our current Article 17.
So, but the manner of voting jointly in the 1987 Constitution is not a new concept, right?
Voting jointly would be definitely new for the amendment or revision, Mr. Chair.
What I'm saying is there are instances in the 1987 Constitution wherein considered of supreme and paramount importance that Congress vote jointly. Like, for example, the revocation or extending the proclamation of the habeas corpus, the revoking or extending the declaration of martial law. These are two supreme and paramount importance wherein in a joint session, Congress vote jointly. Tama po ba?
Mr. Chair, I share the observation that these are important, but if we look at the instances where voting jointly is allowed, when I think, if I am not mistaken, the declaration of the state of war or the revocation of martial law and those instances are not so much because of the importance of the matter, but because of the expediency. So because there is a war or an emergency, it is necessary to gather Congress in one assembly rather than try to have them vote separately. In every other instance, the Congress is bicameral. And bicameralism in the Constitution acknowledges the independence of the branches of the House and the Senate. That is why in the impeachment, just to tie it to that illustration, the UP College of Law Constitutional Law faculty's observation was that the Senate could not dictate upon the House on how it would proceed with the process. So even in non-legislative settings, the default is bicameralism, except in those rare instances of expediency that are reflected in the Constitution.
Brother Rani, you may say something.
Your Honor, without wanting to pick up a quarrel on this point with the esteemed representatives of the University of the Philippines, it's a fundamental precept of constitutional hermeneutics that the intent of the framers is to be found in the text of the Constitution, and that recourse to what happened in the history of the framing is made only when recourse to the text is not sufficient. So whatever the intentions may have been and the historical accidents may have been, the fact is that the text is voting, it doesn't say whether it's voting jointly or voting separately. And therefore, my own position is that there should be no constitutional objection to voting jointly. And my reason for that is that if you say they have to vote separately, then the other objection that could come in there is that Senate, which is composed of far fewer members than the House of Representatives, could effectively interdict any initiative on this matter by the lower house. And that would be, I think, an argument of that voting jointly would not be anathema to the Constitution.
Thank you, Mr. Father Rani. Any other manifestation or comment?
Just to perhaps to respond to Father Rani's intervention, which I think really does follow the idea that the text should reflect the intent of the framers. The framers' intent is reflected in the text, rather. The court nevertheless acknowledges that there are times when there would be ambiguities, and we do resort to rules of construction. One of them, and one that it has depended on quite frequently, is the intent. As to whether the Senate is able to effectively overrule the more numerous House when they have to vote separately, then, Mr. Chair, Your Honors, my submission would be that is precisely the constitutional intent. When bicameralism was selected by the framers, the intent was for policy to be considered carefully by a more numerous House and a smaller House, so the Senate and the House. And in the particular case of constitutional amendments or revisions, it might not be absurd, to put it frankly, for the process of changing the Constitution to be easier than it is to pass normal legislation. If the intent is for constitutions to have some sufficient rigidity so that they do not change with election year policies, then it would be expected that it would be not a very easy task to do. But that is all, Mr. Chair.
But isn't it the fact that all proposals should be approved in a plebiscite called for that purpose? Meaning, any proposals remain a proposal unless inaprobahan ng taong bayan, which is the true honor of the Constitution, yung Filipino people. Because in the parity of voting, the destination of democratic representation in its purest form is, one person, one vote. Tama po ba?
That is right, Mr. Chair. But that, if I may add, that pertains to the popular vote. It doesn't pertain to the rules that the Constitution have created for the members of its two separate houses of Congress.
No, Congress sitting as Constituent Assembly, proposing amendment to the Constitution, we're no longer considered as legislator here, but exercising our constituent power to propose amendment to the Constitution. Tama po ba?
That is right, Mr. Chair. And I hope I am not misciting the case that was also affirmed by the court in Gonzales versus Comelec, 1971 decision. But the court clarified that when a convention or Congress, in this case, exercises constituent power, then the exercise of constituent power is not pure constituent power. It is the exercise of constituent power according to the Constitution. And if the Constitution places certain limits on how Congress can exercise it, then those still have to be complied with and also subject to some judicial review.
Anyway, thank you, Attorney Paulo. Father Rani.
This is not a rebuttal, sir. Number one, when the Constitution says Congress, the Supreme Court has not always interpreted that to be both chambers. When the question once arose on the membership of the JBC and Congress was allotted one seat, the question was, should that not be read as two seats since Congress is bicameral? And the Supreme Court said, no, only one seat. Only one seat. So it is not accurate that the Supreme Court has always read Congress to mean two chambers. And the other thing is that while we may fear that the lower house may introduce changes by sheer propensity of numbers or preponderance of numbers, the ultimate check will be submitting it to the people in a plebiscite or a referendum.
Thank you, Father Rani. So when the Constitution says 2/3 or 3/4 of all its members exercising its constituent power, it does not refer to its legislative power, but the exercise of its constituent power, that ultimately any proposal will go to the approval ng taong bayan. Salamat po. Representative Copilar is now recognized.
Yes, thank you, Mr. Chair. To the Philippine Chamber of Commerce, how can we balance the interests of local business with foreign? To Mr. Christopher Ilagan. Yes. How can we balance the interests of local business with foreign interests if we are going to totally delete the restrictive economic provisions instead of putting the phrase unless otherwise provided by law? Can you respond to that?
Thank you, Honorable Congresswoman Copilar. I'm not a lawyer, so that's just a disclaimer here. No? I guess to the point that we heard from our friends from the Federation of Economic Freedom, no? And I think it was PCCI as well. By removing these restrictions doesn't necessarily mean that you will not have the liberty of passing laws that may put in the proper safeguards, the guardrails, for certain sectors. And I think, when it comes to the likes of national security and what have you, right, it's the laws that come out afterwards that put those restrictions on certain sectors. But, having said that, I think that ultimately what we're looking for, and that's the reason why we need a little bit of time to prepare the position paper. We'd like to word it in a way that it doesn't open up the economy without giving Congress the opportunity to put restrictions where they need to be, especially when it comes to matters such as national security.
Thank you. The reason I asked that, syempre, natakot din tayo na makakainin ng malaking kumpanya yung mga small businesses natin na nagsisimula pa lang. So, we will wait for your position paper. And last, Mr. Chair, I would like to ask Attorney Paolo Tomasio from the Associate Dean of UT College of Law. Since there is a deadlock between the House and the Senate regarding sa interpretation of Section 1, paragraph of Article 17, would it be prudent to seek guidance to the Supreme Court to interpret the said provision? Kasi laging nagtatalo dyan, jointly, separately, but the framers during they drafted the 1986 Constitution is a unicameral system. Eh, hindi naman yon ang nangyayari.
Mr. Chair, thank you for that question. My understanding is that there is no process currently to ask for the court for a pre-clearing of the mode that the Congress would choose. And that also comes from limitations on what judicial power is. We often look at the court's role as the final arbiter of constitutional questions, but the initial answers actually come from the other branches. And Congress is empowered by the Constitution to engage in the same constitutional interpretation. Of course, the result of that in an ambiguous text is really a deadlock, a possible deadlock. So it calls on Congress to do one of two things, in my view. The first thing is, well, the first option is for Congress to test the waters. If it really wants to proceed to a Supreme Court's determination of this, then it can try out the amendment process it wants to, and then wait for the Supreme Court to decide. But the second option, and with all due respect to the Supreme Court, what I believe is the more democratic option, is for Congress not to let the Supreme Court decide this, or just to plant a case for the Supreme Court to ultimately decide on it. There are mechanisms between the House and the Senate for it to coordinate. And one of them might be to clean up whatever ambiguity there is in Article 17.
Supermajority of the members of the House and was transmitted to the Senate. But consistently, the Senate did not act on it. Ang tanong ko po, halimbawa may maipasa ulit kaming resolution ngayon calling for either CONCON or CONAS or a piecemeal amendment to the Constitution at isinumiti namin sa Senado. Sabi mo kanina kasi, wala pang trigger para yung Korte Suprema ay mag-acquire ng jurisdiction over that constitutional question. Yung inaction ba ng Senado that always frustrates those meaningful amendment, proposed amendment to the Constitution, would it trigger shall we call a justiciable controversy?
Mr. Chair, if I may have a few seconds to consult. Mr. Chair, if I may answer the question, at best, the House may argue before the court that inaction would also be in grave abuse. because as part of the equal relationship that the Constitution ordains between the House and the Senate, then the Senate must act on somehow with as to the amendments or the resolution of the House. But that would be, of course, subject to all sorts of objections before the Supreme Court as to whether that duty is actually present, whether that duty is ministerial, and similar objections. But just to add to that, there might be a possibility that the climate this time is different just because of what scholars would call a constitutional moment. That is when the people and the branches of government come to an agreement that there's something that needs to change in the fundamental arrangement of society. And one of the indicators that that constitutional amendment is the frustration, I think, as the three of us mentioned earlier, the flood control issue. So that might be an impetus for the Senate to actually consider a resolution passed by the House, depending, of course, on the substance of the amendment or revision that is proposed from the House. If it pertains to the procedure in Article 17, it might be sufficiently neutral enough to encourage discussion and therefore encourage the Senate to take it on. But if it were to be a more substantive amendment or suggestion, then you would be able to expect some pushback on the part of the Senate. It's just from observing past attempts.
Thank you, Attorney Paolo. To proceed, and the next to ask question is Deputy Minority Leader, Congressman Tino.
Well, Chair, thank you for recognizing me. Actually, siguro I will just share some observations and thoughts. Una, I think sangayon ako kay Congressman Tuno dun sa sinabi niya, no, na bagaman nasa agenda ngayon, kasama yung bills on amendment via CONAS, no? Pero talagang sa panahon ngayon ay hindi, palagay ko hindi papasayan. Given, alam naman natin, no, na dahil sa flood control issue ay napakababa ng credibility ng House at saka ng Senate, no? Kaya matagal nang may palaging nabibigo ang mga tangka na baguhin ang konstitusyon kahit noon pa man dahil ultimately dahil walang tiwala ang mamamayan, no, sa mga nakaupo sa House at Senate, no? Palaging iniisip nila ang gusto lang gawin niyan ay term extension, so on, di ba, mga ganon. Okay, so I would agree with that na kung may panukala man ng pagbabago ay hindi naubra yung moda ng CONAS. Okay, so merong proposal for constitutional convention, maybe yun ang dapat mas pag-usapan if ever. Tapos pangalawang so in other words, ang tanong ngayon, ano ang layunin ng ating mga hearing? Are we here for an academic discussion, okay, of the of proposed amendments, no? Well, if we are, then let me add a few observations. Kaugnay dun sa economic provisions, palaging yan yung isa sa mga major na agenda, tapos matagal na rin, actually, mula pa nung, panahon pa ni FVR, di ba? Diyan na nagsimula yan eh. Yung critique sa Constitution, the neoliberal critique, which is to say, marami daw protectionist provisions ang Constitution, sagka ito sa pag-unlad ng ekonomiya. That critique emerged in the 1990s during the heyday of neoliberalization, of globalization, di ba? Pero So hanggang ngayon, narinig ko pa rin mainly na ganito ang dinadalang posisyon ng mga resource persons natin, lalo pa from the business sector. Okay? Pero sa totoo lang po, lumipas na ang ilang dekada at ngayon, hindi na po unquestioned yung neoliberal dogma that everything should be opened up, protectionism is bad, and so on. In fact, ngayon ay nakikita na ng marami na masama o hindi nakikinabang ang mayorya ng mamamayan sa mundo sa walang sagkang free market globalization. And in fact, this was highlighted during the pandemic. Nakita doon, for example, mahalaga ang proteksyon at pagpapalakas sa sariling produksyon. No? Local industry, local manufacturing, local or domestic agriculture. No, nung panahon ng pandemic, nakadepende tayo sa practically nagmakaawa ang si Duterte sa Vietnam. Vietnam, please, during the pandemic, wag niyo itigil ang importation ng bigas, no? So, kumbaga nagbabago na rin po ang economic ang nauusong mga economic doctrine ngayon. So bumabalik yung recognition sa kahalagahan ng protection and development of our own industry and agriculture. No? So yun lang po ay unfortunately sa mga resource persons na narinig natin dito, parang di pa rin na yung pa rin mga dati ang naririnig ko na basically pro-importer. No, na dapat, we don't want a protection of local monopoly, so buksan natin sa importation. Nakikinabang ang mga komprador na tinatawag ng mga aktivista, mga burgesyang komprador. Tapos, to the detriment, okay, laging pabor sa importer. So nakita natin, pag pabor sa importer, actually, nawawasak ang lokal na agrikultura natin. Pabor sa importer, wala tayong domestic industries. In the 90s, we saw a wave of economic growth in our neighboring Southeast Asian countries, yung Malaysia at Thailand. Bakit sila umunlad? Dahil nag-focus sila sa manufacturing, hindi lang assembly. There was technology transfer, so meron silang mga sariling industriya na na-develop. Ngayon, there's another wave. Andiyan na yung Vietnam, yung Cambodia. Again, susi doon, manufacturing. Mamaya, maiwanan naman ng Pilipinas, mamaya, maiwanan naman tayo ng Laos. Ganun na. No? So, siguro yun lang po, Mr. Chair, yun ang mga punto na nais kong i-share dito na una, baka dapat tanggapin ng komite na dead in the water na tong CONAS. No? Pangalawa, nire-raise ko lang na dapat questionin natin yung neoliberal dogma. Okay, napangiiwanan na po yan ngayon. At mas mahalaga ang pag-focus sa national industrialization at saka sa pagpapaunlad ng ating agrikultura. Yun lang po, Mr. Chair.
Thank you, Congressman Theo. May we recognize Congressman Benny Abante of the 6th District of Manila. Sir, thank you for coming. Next to ask question is the Vice Chair of this committee, Congresswoman Lagbas. You're now recognized.
Thank you, Mr. Chair. I just wish to manifest my full support on continuing support as well for House Bill number 5870 and House Bill 460 measures that I have already joined as author. While my authorship already places me on record, Mr. Chair, I wish to reiterate this here in the committee to underscore the need for an inclusive, transparent, and participatory process. Constitutional reforms requires perspectives not only from legal and academic experts, but also from the communities that will ultimately be affected by these changes. While we are all here today, naisip ko po yung mga kapatid natin na nasa grassroots. Siguro nagwa-wonder sila kung ano na naman ang direction natin, kung ano yung proseso. May I kindly ask po from the resource speakers, what are the specific measures that you can suggest for this committee to undertake to somehow bridge the deep disconnect of this committee of the constitutional reform and the people from the grassroots? Yes, Mr. Chair, I would like to ask the opinion po of the resource speakers na pag-usapan po natin na importante po yung proper dissemination ng information din sa grassroots and all, as eventually sila naman po ang affected kung ano man ang mga pagbabago sa Philippine Constitution. Sa dami pong instances na nag-take ng effort ang Constitutional Amendment Committee para po ipagpatuloy ang amendments ng Constitution, yung mga tao po natin, mga kapatid natin sa grassroots ay palagi pong may distrust sa proseso. Would you possibly have a concrete suggestion on how to alleviate this distrust from the grassroots po?
Any would like to answer of the resource persons?
Thank you, Mr. Chair. If I may answer the question. If we look at past, kung titignan po natin yung mga nakaraan na pagsubok ko doon sa pagpapalit ng saligang batas, hindi po natutuloy yung pagpapalit. Kung mayroon man kagustuhan talaga yung tao na magpalit, dahil may perception po na nire-railroad yung proseso. To be very frank, na minamadali yung proseso. Yung saligang batas po natin, sa ayaw man o sa gusto natin, itinakda po talaga siya na hindi madali baguhin. At kaya po siya hindi madali baguhin ay kung titignan kasi yung karanasan natin sa ilalim ng diktadorya, madalas na ginamit yung pagpapalit ng saligang batas upang mapatagal sa pwesto si dating Pangulong Marcos. So, baked in na po, no? Malalim po yung distrust ng mamamayan doon sa proseso ng pagpapalit ng saligang batas. Yung isa po siguro na pwede natin gawin upang mapalapit lalo sa grassroots yung usapin na ito ay sundin po yung pinaka-konserbatibong interpretasyon ng pagpapalit ng saligang batas. Kung mayroon naman po kasi talagang kagustuhan sa lipunan, susuportahan po ng mamamayan iyon. Ngunit, gaya ng mga panukala sa Kongreso sa nakaraan na pinaghirapan din naman talaga at nakabuti, kinakailangan po yung buy-in ng mamamayan, no? Yung acceptance ng mamamayan para sa success ng mga panukala na iyon. So, yun po yung from the legal side, no? Yung mamumungkahi po namin, hindi po madali yung proseso at minsan nakakainip po siya. Pero baka kailangan po natin siya sundin ng tapat upang mapakita sa mamamayan na seryoso, in good faith yung ginagawa natin. Maraming salamat po.
Thank you.
Makakatulong po ba if at this early stage ay mag-invite na rin tayo ng mga representatives ng mga people's organization or youth organization para po sa simula pa lamang ay maramdaman nila nakasama sila sa proseso at importante din pong marinig ang boses nila.
Thank you, Congresswoman. Now, I'd like to ask our members if you have some questions for those. Yeah, Congressman Pandaligan.
Thank you very much, Mr. Chair. When we ask an opinion from our resource persons, particularly from the law deans, regarding this issue, because now we have a deadlock for a long time. We cannot pursue constitutional amendments because the Senate never agreed on the proposals coming from the House because of the ambiguity of Article 17, particularly the so-called first mode Constituent Assembly. We have passed a resolution here, for example, in the last Congress, March 2024, RHP number 7, that our good chairperson sponsored. However, of course, it didn't reach the Senate, no? Or it reached the Senate, but it wasn't acted upon. So we have a deadlock because of the issue of voting. But I remember that in the hearings conducted last time, the so-called Bernas formula cropped up. Our own chairperson, in fact, stated, no, that we can try the Bernas formula. But of course, it was criticized by some of the resource persons then as violating of the Constitution. They allege that it is the fourth mode which is not allowed. However, personally, I believe that that isn't the fourth mode. That is just operationalizing the first mode. Because if we will not do that, then the first mode will be rendered nugatory. And I don't think the framers of the Constitution intended to craft a provision that will be negated. But because of their ambiguity, or because they neglected to clarify that, I think Congress has the right to try that so-called mode, wherein we will treat an amendment, a resolution, a proposed amendment, as an ordinary legislation. But of course, complying with the requisite 3/4 vote of both houses. So we vote 3/4 here, we send it to the Senate, they vote 3/4 also, assuming they will agree. Then we can have an amendment. That is my point, to break the deadlock and to render Article 17 operational. So maybe we can get some insights from our law deans here.
Dean Rani, about the comments of Congressman Panaligan.
The Bernas formula.
Mr. Chair, may I request, Your Honor, that he formulate very briefly, paano yung formula mo?
It will be treated. According to Father Bernas, there is a way out. We treat the proposed amendment like an ordinary legislation. So the House will enact the proposal with the requisite 3/4 vote. The Senate will also enact the proposal with 3/4 vote. So we'll come up with a law, an act amending the Constitution. And then, of course, it will be submitted to the people. According to Father Bernas, that will solve the ambiguity. Of course, it will reach the Supreme Court, and that will be the opportunity for the Supreme Court to decide.
Well, that's actually the first mode, Congressman, except that instead of voting jointly or meeting jointly, they would still be voting separately. I wouldn't have any problems with that. But if Senate maintains its adamant position against this, it will always stand in the way. You will never get the 3/4 that you need. You know, Congressman, one way I see out of it is if by sufficiently mobilizing the people and informing them so that the people are not used, people's initiative is used to amend that constitutional provision to make it clear that 3/4 is voting jointly, so that amendment is introduced by initiative, then you can break through the deadlock. The moment voting jointly has been placed there by initiative, the amendment can go ahead. Because if you wait for the Senate, ultimately, as our Vice Dean from UP says, if the lower house goes ahead and Senate does not agree, you will end up with the Supreme Court making a decision which brings in the whole counter-majoritarian difficulty in legal theory.
Father Aquino, from the UP, and we have your comment about the Bernas proposal.
So, Mr. Chair, subject to, I think we will take that suggestion and address it in the position paper. There might be a way to actually comply with the requirement that the Houses vote, or the perceived requirement that the House vote separately. If to cite Justice Mendoza and his views on this, his view is that when Congress considers changes to the Constitution, it wears a different hat. It wears a constituent hat. And therefore, the perspective of Congress needs to also change when it considers it. And that's why a separate meeting is being proposed by Justice Vivi. But we'll look into this more deeply and see if there is a way to reconcile both Justice Mendoza's view and Father Bernes's view, and put that in our position paper.
Thank you, Assistant Dean Tamase. Now, I think for, Bernie, Chair Abante will now ask the question.
Mr. Chair, I'm sorry for coming in late because I was in, alam mo, multitasking tayo ngayon, di ba? The thing is this, no? We have been talking about constitutional change since the time of President Ramos until today. And always, the question is, wala sa timing, di ba? So, when is the time? Perhaps right now, what is happening to our country, it is time for us to have this constitutional change. Now, yung pinapaliwanag kaninang Constituent Assembly, pinag-usapan na ng husto yan eh. In the last congresses, of which I'm a part of. Pinag-usapan na po yan at talagang matindi ang division dyan between the House and the Senate. And because of this, merong isang option sa ating konstitusyon. And the option is Constitutional Convention na pinanggit mo yung mamamayan, di ba? Yun namang ibang mga resource persons natin nung araw, binabanggit ang mamamayan, hindi naman sila nag-represent sa mamamayan. Ngayon, we would like the mamamayan to be represented. In the Constitutional Convention, all of the people will be represented. And this is the work of Congress. Nakalagay po dito, Article 16. 16 ba yan? Yan. 17. 16, di ba? 17, no? Ano nakalagay? The Congress shall provide for the implementation of the exercise of this right. It is the duty of Congress. Kaya pinag-uusapan po natin ngayon. Hindi naman yan pwedeng pag-usapan sa City Council. Hindi naman pwedeng pag-usapan yan sa board, provincial board. Hindi pwedeng pag-usapan yan sa barangay. Kaya pinag-uusapan natin sa National Congress. And I believe that all the people should realize that it is the mandate of Congress when it comes to the amendments of the Constitution, whether it be Constituent Assembly. Sinep na natin yan eh. Hindi na natin pinag-uusapan ngayon yan. Ang pinag-uusapan natin ngayon, Constitutional Convention. Hindi natin pinag-uusapan kung ano dapat pag-usapan pa dyan. We will not tell the would-be delegates of the convention what to do and what provision should be tackled. Bahala na sila dyan. Kung anong pag-usapan nila, bahala na sila. Whether it be economic provisions or political subdivisions, bahala na ang Constitutional Convention dyan. Ang ginagawa po natin dito, ito yung aking bill, an act constituting a Constitutional Convention to amend. Not anymore Congress telling the delegates, itong i-amend ninyo. Kayo na bahala dyan. Because we cannot even prevent them to what they're going to amend. Am I right? As long as it is the people that have actually voted for the delegates of the Constitutional Convention, yun ang hanap natin. Let the people so decide.
Thank you, Chairman Abante. So, are there any more comments and questions from the members? Because then we will suspend to have our lunch. And then we will resume at 1 o'clock for the second group of resource persons. Wala na? So with that, this is no more questions from the members of the committee and members of Congress. We would like to thank all our resource persons for taking time to come to our hearing. Thank you very much. And we hope to get your resource persons to your papers, position papers, and we'll put a matrix and we will give it back to you so that you can also correct them if not properly encoded. So thank you very much. Let's have lunch. And then, so therefore, may I suspend the hearing of this committee? Suspended.